Imagine a congressional map that dictates the political voice of millions being erased, redrawn, and then unexpectedly reinstated in the span of just a few weeks, right as voters are heading to the polls. The ongoing battle over Alabama's congressional districts has pushed the American electoral system and really the Voting Rights Act itself to the absolute brink. If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released. As a quick update, we continue to monitor the Martin Stevens v. OpenAI matter. It is important to note that this is still not a lawsuit. We remain in a voluntary quiet period at the request of Martin Stevens to allow time for any potential developments behind the scenes. At the time of this recording, we do not know whether any progress has been made. No settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change. Welcome to the debate. Today's discourse focuses on the June 2026 Supreme Court ruling in Allen v. Milligan, the application of the Purcell principle in election law and, well, the escalating tension between the Voting Rights Act and the 14th Amendment's Equal Protection Clause.
Right, and the central question before us today is this. Does the Supreme Court's current trajectory, specifically looking at the Calisay standard and the really strict application of the Purcell principle, represent a necessary, neutral correction to avoid unconstitutional racial gerrymandering and election chaos?
Or, conversely, does it weaponize procedural doctrines to dismantle the Voting Rights Act and essentially reward states for defying federal court orders? I will be arguing that the court is correctly enforcing constitutional limits. By requiring race-neutral districting criteria and utilizing the Purcell principle, the court is protecting the integrity and stability of imminent elections from last-minute judicial interference.
And I will be arguing that the court is selectively applying the Purcell principle and imposing impossible substantive hurdles to effectively nullify Section 2 of the Voting Rights Act. By doing so, I believe it prioritizes states' procedural maneuvering over voters' fundamental rights.
Okay, so to set the baseline here, we really have to look objectively at what the 14th Amendment actually demands. It strictly forbids race from predominating in government decision-making. Period.
Well, it forbids it unless it can pass strict scrutiny, but yes.
Right, exactly. And that prohibition includes the drawing of congressional districts. The newly updated standard from the Supreme Court in Louisiana v. Calais recognizes this. It demands that when plaintiffs propose alternative maps to prove a Voting Rights Act violation, those maps must meet all of a state's legitimate districting objectives.
Such as?
Well, like preserving specific communities of interest, say the Gulf Coast in Alabama, and they have to do that without using race as the primary criterion. But crucially, plaintiffs must explicitly control for party affiliation. Section 2 of the Voting Rights Act cannot just be used as a backdoor for partisan gerrymandering.
I mean, I understand the theory behind the 14th Amendment's colorblind ideal, but the 2026 per curiam ruling is an unconscionable abandonment of the rule of law as it functions in reality. We really have to look at the actual procedural timeline here, because the facts are just glaring.
Go ahead.
The district court's remedial map, which was drawn by a special master, was the actual status quo. It was the exact map used successfully in the 2024 elections. It was already in the county-level voter rolls. So the Supreme Court's last-minute intervention to vacate that injunction and reinstate a map that a federal court found historically discriminates against Black Alabamians actually causes the very chaos the Purcell principle was supposedly designed to prevent.
I know we'll dive deeply into the definition of status quo shortly, but first, let's acknowledge the other critical piece of my position, which is the Purcell principle itself. In June 2026, invoking Purcell to restore Alabama's 2023 map was a necessary practical safeguard.
A safeguard for who?
For the entire electoral system. Federal courts cannot legally or logically force states to overhaul their electoral mechanics on the eve of an election without causing catastrophic administrative chaos. The status quo of a democratic system must inherently be the laws passed by its elected legislature, not the temporary mandates of unelected judges.
And I think that framing completely ignores how the court is actively misapplying this doctrine. Academic frameworks point out a profound difference between a positive Purcell application, one that imposes voting restrictions, and a negative Purcell application that removes them. By using Purcell to force a discriminatory map back into play days before a primary, the court is misusing an equitable principle to maximize rather than minimize voter disenfranchisement.
Let's back up and trace exactly how we arrived at this critical juncture in June 2026, because the legal saga of Allen versus Milligan really begins following the 2020 census.
Right.
The state of Alabama, where the population is roughly 27% black, enacted a congressional map in 2021 that maintained only one majority black district out of 7.
Yeah, and civil rights groups rightfully challenge this under Section 2 of the Voting Rights Act, because a 27% demographic should not be packed and cracked into a single district. In early 2022, a 3-judge district court panel, which, by the way, included 2 judges appointed by conservative presidents, enjoined that map, finding it likely diluted black voting strength.
Well, the Supreme Court, invoking Purcell, stayed that injunction. They allowed the 2021 map to be used for the 2022 midterms to avoid immediate chaos. And then came what many considered a shockwave. In June 2023, the Supreme Court actually affirmed the district court in a 5-4 decision.
Oh, it was a massive shockwave.
Exactly. They struck down the 2021 map and ordered Alabama to create a second district where black voters had an opportunity to elect a candidate of their choice.
Right. A direct, explicit order from the highest court in the land. So what did the Alabama legislature do? They went back to the drawing board in 2023 and passed a new map that still contained only one majority black district.
Well, they drew a second district.
A second district that had a black voting age population of less than 40%, which demographic experts testified was nowhere near enough to actually elect a candidate of choice.
But we need to look at why they drew it that way. Yes, the district court was furious. After an exhaustive 11-day trial featuring 51 witnesses, they permanently enjoined the 2023 map, imposed a court-drawn remedial map for the 2024 elections, and accused the state of outright defiance. But I fundamentally challenge the premise of that defiance.
How can you possibly challenge that? They were told to drop 2 opportunity districts, and they drew 1.
Because the rules of the game are far more complex than just hitting a demographic quota. If a referee changes the strike zone mid-game, a pitcher adjusting their throws isn't cheating, they're adapting to the new rules. Alabama was not acting in bad faith. They were navigating a genuine, excruciating legal tension between complying with the Voting Rights Act and avoiding the 14th Amendment's strict prohibition on racial targets.
What new rules were they adopting to? The Allen decision in 2023 reaffirmed the exact same Gingell's framework we've used since the 1980s.
They were specifically taking cues from Justice Thomas's 2023 dissent regarding racial predominance. And frankly, they were reading the tea leaves of the court's shifting broader jurisprudence on race. If a legislature explicitly sets out to draw a district that is 51% black, they are allowing race to predominate the map drawing process.
To remedy a past violation.
But under the 14th Amendment's Equal Protection Clause, that is unconstitutional unless it passes strict scrutiny. Alabama was trying to thread a needle that the court's own jurisprudence has made increasingly microscopic, which is, fix a racial disparity without using race as the primary tool to do it.
I have to stop you there because the record established by the district court explicitly contradicts the notion that the Alabama legislature was simply, trying to navigate complex legal waters. We have to look at what actually happened in Montgomery during that special session.
Okay, what happened?
Let's look at the words of the Speaker of the Alabama House of Representatives, Nathaniel Ledbetter. After the 2023 Allen decision came down against them, he pointed out that the ruling was 5-4. He publicly stated, and I quote, "So there's just one judge that needed to see something different."
Legislators make political statements all the time.
That is not just a political statement. That is a calculated legal gamble, and it proves intent. That is not a legislature acting in good faith to comply with a federal court order. They weren't threading a needle to comply with the 14th Amendment. They were waiting out the clock, hoping the composition or the mood of the Supreme Court would shift. They were banking on flipping one conservative justice who might have been on the fence.
You're pointing to one quote from a politician to establish the intent of an entire legislative body. What about the actual map drawing process itself?
Let's talk about the map drawing process. The district court's 11-day trial wasn't just a political debate. It was deeply, rigorously empirical. 51 witnesses, almost 800 exhibits. The court examined the specific algorithms and mapping software the legislature used. They found that Alabama conjures legislative findings out of thin air in the dead of night.
What exactly do you mean by conjuring findings? I know that's a dramatic phrase from the court, but what is the actual mechanism?
The mechanism is manipulating the criteria to guarantee an outcome. During the special session, the legislature created a brand new set of redistricting guidelines that they had never previously employed. They suddenly decided that keeping the Gulf Coast counties of Mobile and Baldwin together was a paramount, non-negotiable state interest.
And why is that problematic?
Because the Black population in Alabama is heavily concentrated in the rural Black Belt, which stretches across the middle of the state. If you draw a map that mathematically locks in the white majority Gulf Coast counties and refuses to split them, it becomes mathematically impossible to draw a second Black opportunity district that connects the Black Belt to Mobile.
But preserving communities of interest is a standard, legitimate redistricting principle recognized nationwide.
It is, but they didn't care about the Gulf Coast community of interest in 2021 when it suited them differently. They only suddenly elevated it to a sacred, inviolable rule in 2023 precisely because it blocked the creation of a Black district. The court found this as a matter of fact. When the empirical evidence shows a state actively subverting a direct court order by manipulating its own districting criteria to guarantee a discriminatory outcome, we cannot simply brush that off as adapting to new rules. They were openly defying the Voting Rights Act.
I hear the frustration, I do, but we have to look at the structural reality of the legislative process. The creation of legislation, especially something as fiercely contested as redistricting, is inherently messy. What the district court interpreted as conjuring findings out of thin air was the legislature attempting to formalize race-neutral criteria. If they are told they cannot prioritize race, they have to prioritize geography. Mobile and Baldwin counties are a distinct economic and cultural zone tied to the Gulf of Mexico.
But the timing of that prioritization really matters.
It matters, but it doesn't make it inherently unconstitutional. And this tension is exactly what the Supreme Court recognized in the Louisiana versus Calais ruling in early 2026, which fundamentally shifted the landscape of this entire debate. To understand why Alabama's actions in 2023 and 2024 make legal sense in 2026, we have to talk about how Calais changed the game.
Before we dive into the weeds of Calais, we really need to explain to the listener what it replaced. For 40 decades, Voting Rights Act cases have been governed by the Gingell's preconditions established in 1986.
Right, the three prongs.
Exactly. To prove a map dilutes minority votes, plaintiffs had to prove three things. First, the minority group is large and compact enough to constitute a majority in a single-member district. Second, the minority group is politically cohesive, meaning they vote together. And third, the white majority votes sufficiently as a bloc to usually defeat the minority's preferred candidate.
Exactly. And for 40 years, that third prong, racially polarized voting, was the battlefield. But Callies updated that standard to reflect modern reality. Under Callies, a plaintiff's proposed alternative map cannot just be drawn to hit a racial quota. It must meet all of the state's legitimate districting objectives, like preserving the Gulf Coast, just as well as the state's own map, without using race as a districting criterion.
Which is incredibly difficult if the state reverse engineers its criteria to block minority representation.
But here's the most critical part of Callies, and the mechanism we really need to understand. To prove racially polarized voting today, plaintiffs must provide an analysis that explicitly controls for party affiliation. They must show mathematically that racial bloc voting cannot be explained simply by partisan preference.
And how exactly are plaintiffs supposed to do that in the real world?
By using statistical modeling. They have to prove that white voters are voting against Black candidates because those candidates are Black, not simply because those candidates are Democrats. This is a vital evolution in the law. Section 2 of the Voting Rights Act was designed to prevent racial discrimination. It cannot serve as a Trojan horse for partisan gerrymandering.
But that assumes you can cleanly separate the two variables.
You must separate them. If a map is drawn by a civil rights group to maximize Democratic seats under the guise of protecting minority voting rights, it perverts the VRA's noble goal. In states like Alabama, where race and politics overlap significantly, we must disentangle them to ensure we are enforcing civil rights, not just guaranteeing partisan outcomes. If we don't control for partisanship, how do we possibly protect the 14th Amendment's mandate for colorblind government action?
That argument sounds brilliantly logical in a sterile academic vacuum. But let's apply it to the empirical reality of the Deep South. Let's look at the analysis provided by Bill Britt on this exact disentanglement problem. How can the law realistically demand that we separate race and politics when historically and empirically they are perfectly correlated in Alabama?
They are highly correlated, yes, but they are not the same thing.
Statistically, they are almost indistinguishable. Let me give you an analogy. It's like asking someone to sort a standard deck of cards by suit, but telling them they are legally forbidden from looking at the colors, red and black.
In the Deep South, the red cards are almost entirely hearts, and the black cards are almost entirely spades. Black voters in Alabama overwhelmingly vote for Democratic candidates, often upwards of 90%. White voters overwhelmingly support Republican candidates. This polarization isn't a coincidence. It is the direct legacy of historical disenfranchisement, Jim Crow, and the racial realignment of the political parties in the 1960s.
No one is denying the history, but the 14th Amendment applies to the present.
But the mechanism of the Calais Standard ignores the present reality. To demand that civil rights plaintiffs control for partisanship in a region where historical discrimination has perfectly polarized race and political affiliation is an evidentiary catch-22. It is a mathematical hurdle specifically designed to make Section 2 claims functionally impossible to win. How do you run a statistical regression controlling for a variable that is perfectly collinear with the variable you were testing?
Well, you look at primary elections for one. How do black and white voters behave when there's no Democrat versus Republican dynamic, but rather two Democrats running against each other?
They do look at primaries, and the data still shows racial polarization. But let's look at the facts of the Alabama trial itself regarding the state's intent. You're arguing we must protect against partisan gerrymandering, yet there was minimal evidence that partisanship even entered the Alabama legislature's calculus when they drew the 2023 map.
Every map drawn by a legislature is inherently partisan.
But their own formal redistricting criteria omitted any mention of partisanship. Neither of the legislators who led the process testified that they drew the map to protect Republicans. In fact, they ignored explicit urging from former House Speaker Kevin McCarthy, who publicly told them to focus on partisan gains. They denied doing it for partisan reasons under oath. Yet the Supreme Court in the June 2026 per curiam opinion faulted the district court for departing from Calais by not controlling for party affiliation.
Because the objective data showed the correlation regardless of what the legislators admitted to.
Think about what you're saying, though. How can plaintiffs be legally required to control for a variable that the state's own map makers claimed under oath they didn't prioritize, in a state where race is the absolute strongest predictor of political affiliation? It transforms the Voting Rights Act into an illusion. You're asking plaintiffs to prove a negative against a shifting standard.
I have to push back hard on this idea that the Calais Standard makes things impossible, because it effectively surrenders to the idea that race and politics are permanently legally fused. That is a bleak outlook that the Constitution simply does not permit the government to adopt.
It's not a bleak outlook. It's a statistical fact.
But the 14th Amendment requires the state to treat citizens as individuals, not as permanent components of racial blocs. If the data shows that voting patterns are driven by partisan alignment, even if that alignment strongly correlates with race, then a map that disadvantages Democrats is just a partisan gerrymander. And as the Supreme Court established explicitly in Rucho v. Common Cause in 2019, federal courts have no jurisdiction over partisan gerrymandering. It is a non-justiciable political question.
But you're putting the cart before the horse. You're assuming it's a partisan gerrymander that happens to hit black voters. I'm telling you it's a racial gerrymander that happens to hit Democrats.
It is not that simple to prove your case. It demands analytical rigor to tell the difference. It forces plaintiffs to prove that the dilution of voting power is driven by racial animus or racial polarization,
not just standard issue, bare-knuckle American political competition. If plaintiffs cannot mathematically separate the two, then federal courts have no constitutional basis to intervene and invalidate a state's sovereign legislation. It's that simple.
It is not that simple because the federal court did find intentional racial discrimination in this specific case. Let's be very clear about what the district court ruled after those 11 days of testimony. It wasn't just an accidental disparate impact. They found that Alabama violated the 14th Amendment because the 2023 map was a deliberate refusal to satisfy the remedial requirements. They intentionally targeted the Black population to dilute their vote.
The district court made that finding, yes.
Right. And this brings us to the procedural mechanism the Supreme Court used to obliterate that finding of fact, the Purcell principle. Because the Supreme Court didn't actually strike down the district court's factual findings on the merits in June 2026, they used a procedural shadow docket maneuver to bypass them entirely.
It wasn't a shadow docket maneuver. It was an emergency application for a stay based on established precedent. Let's explain what Purcell actually is. Purcell v. Gonzalez, decided in 2006, generally holds that federal courts should hesitate to alter state election laws close to an election to avoid voter confusion and administrative chaos.
And the Supreme Court majority in the 2026 Allen order ruled that the district court improperly altered election rules on the eve of the election, interposing itself into Alabama's efforts to use its elected representatives' maps.
Which is exactly what happened. The primary was weeks away.
But let's look at the fundamental mechanics of how an election actually works. Let's look at step 0 of a Purcell analysis, establishing the status quo. What is the baseline reality before the court intervenes? As Justice Sotomayor masterfully argued in her dissent, the district court's remedial map, the one the Supreme Court threw out in June 2026, was the actual physical status quo.
Legally, the status quo is the statute passed by the state.
Operationally, the status quo is the database maintained by the county clerks. The remedial map was the exact map used seamlessly in the 2024 congressional elections. Think about the mechanism here. To run an election, county officials take a map and geocode every single residential address in the state to a specific precinct and a specific congressional district. They had already done this for the remedial map. That data was already loaded into the county-level voter rolls. The ballots were being designed based on that data.
But that map was a temporary remedy.
The 2023 map, just days before the 2026 primary, required elections officials to strip that data out and reassign hundreds of thousands of voters in a matter of days. Imagine being a poll worker. A voter shows up, their registration card from 2024 says they are in District 2, but the newly updated iPad database says they are in District 7. They are handed a ballot with candidates they've never heard of. That is the definition of a Herculean effort, resulting in massive voter confusion. The Supreme Court didn't prevent chaos, they manufactured it.
I see the mechanical argument you're making, but we have to look at the structural philosophy of our government. I frame the concept of the status quo quite differently. We have to use a constitutional analogy here. The status quo in a republic must inherently be the legislation passed by its duly elected bodies, not a temporary mandate drawn by an unelected special master.
Even if that legislation is unconstitutional?
Until it is finally struck down on the merits, after a full appeals process, the state enjoys a presumption of constitutionality. The district court created the chaos by permanently enjoining a legislatively enacted map and substituting their own judgment. When an unelected federal judge replaces a legislature's map, they are disrupting the fundamental democratic baseline. The Supreme Court, in vacating that injunction, was merely restoring the proper democratic order.
By forcing poll workers to scramble and voters to guess their districts.
As the per curiam opinion explicitly noted, conducting elections under court-imposed maps simply because it is more convenient for the state's IT systems is not a valid justification for judicial intervention. States are sovereign entities. They are free to decide for themselves whether last-minute changes to an election are in their best administrative interests.
The state isn't the one suffering the injury. The voter is.
But the Purcell principle exists to prevent federal judges from micromanaging state elections at the 11th hour. If the state says, we can handle the administrative burden of implementing the map our legislature actually passed, it is not the place of a single federal judge to say, no, your IT systems can't handle it. Use my map instead.
The state knows its capabilities better than the court does.
I reject that premise entirely because the academic literature demonstrates that your framing fundamentally distorts the actual text, history, and intent of Purcell. Let's look at the framework developed by Harry B. Dodsworth in the Utah Law Review. Focusing on a theoretical legal status quo, the abstract idea that a legislatively enacted map is always the default misses the entire point of the Purcell doctrine.
How does it miss the point? Purcell is about preventing judicial interference.
No, Purcell is explicitly about preventing voter confusion that leads to voter chill. Read the original 2006 opinion. It is entirely focused on the psychology of the voter. It warns that complex last-minute court orders can cause voters to simply stay home. It is not about protecting abstract state sovereignty from federal oversight.
State sovereignty and orderly elections go hand in hand.
Changing the physical voting districts, reassigning voters, and altering where people cast their ballots days before an election is what causes the very confusion Purcell warns about. A voter standing in line doesn't care whether the map was drawn by a state legislature or a federal judge. They care whether they know what district they live in, who the candidates are, and where their polling place is.
And Dodsworth's framework explains this?
Exactly. Dodsworth analysis divides Purcell applications into positive and negative categories. This is crucial for understanding how the court is misusing the doctrine. Positive orders are injunctions that add new voting restrictions or alter procedures in ways that produce under-inclusive behavior.
Meaning what, practically?
Move restrictions. They might cause over-inclusive behavior, like a voter bringing an ID to the polls when the court just ruled they don't need one. Over-inclusive behavior is mostly harmless. It doesn't stop anyone from voting. So Dodsworth argues courts should treat these differently. Right. Dodsworth argues there should be a presumption of no confusion for negative orders. If a court strikes down a restriction, the appellate courts shouldn't use Purcell to reinstate it, because removing a hurdle doesn't chill voters. But by stepping in to force a massive redistricting overhaul days before the primary, reinstating a map that packed and cracked minority voters, the Supreme Court engaged in a profoundly disruptive, positive application of Purcell. They actively created the voter confusion and disenfranchisement the doctrine was supposed to prevent just to protect the state's ego.
That is a fascinating academic framework, but let me explain why Dodsworth's theory falls apart when you apply it to the reality of redistricting. I challenge the idea that redistricting can be neatly categorized as a negative order that simply removes a restriction.
It removes the restriction of an unconstitutional boundary line.
But look at the mechanics. As Justice Kavanaugh noted in his concurrence in the 2022 Merrill decision, redrawing congressional maps isn't a simple, harmless, negative order. It's not like temporarily waiving a photo ID requirement or extending a mail-in ballot deadline by 24 hours. Those are binary switches. Redistricting is fundamentally, structurally destabilizing to the entire political ecosystem.
Because it creates fair districts?
Because of the massive ripple effects. If a federal judge draws a new map weeks before an election, it forces candidates who have been campaigning for months to suddenly switch districts or drop out entirely because they no longer live where they are running. It pits long-standing incumbents against each other unexpectedly. Millions of dollars in campaign spending are instantly rendered useless. It requires massive systemic back-end administrative overhauls by election officials to print entirely new ballots.
But again, in 2026, the remedial map was already in place. The state had already done that back-end work.
But the principle holds. You cannot apply a presumption of no confusion to a court order that redraws the boundaries of political representation for millions of people. It is the ultimate positive disruption. The district court's insistence on throwing out the legislature's 2023 map and permanently imposing a court-drawn map for the 2026 cycle was a profound overreach. It violated the court tenet of Purcell, which is, federal courts should not alter fundamental election rules on the eve of an election. The Supreme Court was entirely consistent in stepping in to halt that overreach.
I will concede that redistricting is uniquely complex and administratively burdensome. We aren't just talking about waiving an ID requirement, but we cannot analyze this administrative burden in a vacuum. The courts are supposed to weigh equities. We must weigh the state's administrative headache against the severity of the constitutional injury inflicted on the voter.
And the Purcell principle weighs those equities in favor of the election calendar.
But at what cost? If a federal court, after an 11-day trial with 51 witnesses, finds as a matter of fact that a map violates the 14th Amendment and mathematically entrenches racial discrimination, then using the Purcell principle to reinstate that map actively maximizes disenfranchisement. It literally forces an entire class of citizens to vote under a system specifically engineered to dilute their political power.
For one election cycle, until the merits are fully adjudicated.
One election cycle dictates control of Congress. Voting rights are not retroactive. You can't give someone their vote back a year later. As Doddsworth points out, Purcell is supposed to be an equitable balancing test within the public interest prong of a preliminary injunction analysis. It is not an absolute bright-line rule. It is not a procedural magic wand that states can wave to make unconstitutional restrictions disappear just because the calendar says it's an election year.
But it has to be a firm rule, otherwise every election is litigated up to the night before voting starts.
Look at how it is actually weaponized, though. By consistently using Purcell to block lower court remedies that protect minority voters, which the Supreme Court did repeatedly throughout the 2020s in Alabama, Louisiana, Georgia, and elsewhere, the court has inverted the doctrine. It now serves as an impenetrable shield for discriminatory state action. A state can pass an unconstitutional map, intentionally delay the discovery process, drag out the trial, and when they finally lose, they just point to the calendar and say, oops, it's too close to the election. Purcell says we get to use our illegal map.
I think that fundamentally misreads the motives of state actors. It assumes the state is intentionally manipulating the calendar as a bad faith strategy, when in reality, complex redistricting litigation simply takes years to resolve. Discovery takes time, statistical modeling takes time, appeals take time.
And the state controls the timeline of the appeals.
But more importantly, your argument ignores the profound shift in the underlying substantive law that actually justifies the Supreme Court's procedural caution. The court isn't just using Purcell to dodge the issue. They are using it because the underlying legal foundations of these VRA claims are fundamentally shifting. Which brings us to the most critical existential question raised by this entire Alabama saga, and that's the future of Section 2 of the Voting Rights Act itself.
This is where the real danger lies. The procedural roadblocks are just a precursor to the substantive gutting of the law.
Let's look at the jurisprudence. In his 2023 concurrence in Allen, Justice Kavanaugh explicitly signaled his openness to an argument long championed by Justice Thomas. Thomas has argued that the authority of the federal government to mandate race-based redistricting under Section 2 cannot extend indefinitely into the future.
The sunset theory.
Precisely. As the Fordham Law Voting Rights and Democracy Project analyzed extensively, the court is clearly laying the groundwork to declare Section 2 unconstitutional as applied to redistricting based on this sunset theory. And from a strictly constitutional perspective, this makes perfect sense. The Voting Rights Act of 1965 was an extraordinary piece of legislation. It was a massive, unprecedented federal intrusion into state sovereignty.
It was justified by a century of horrific, systematic violence and disenfranchisement during the Jim Crow era.
Absolutely. It was profoundly justified by those horrific abuses. But in American constitutional law, extraordinary remedies cannot be permanent features of our architecture. The 14th and 15th Amendments demand equal protection and colorblindness. If the ultimate goal of those amendments is a truly colorblind society, statutory law must eventually evolve to reflect that reality.
So you're saying the disease is cured, so we can throw away the medicine?
I'm saying the specific medicine prescribed in 1965 has toxic side effects if taken forever. We cannot rely indefinitely on the 40-year-old framework of Thornburg versus Jingles, which inherently demands race-conscious map drawing. It forces state legislatures to divide voters by race, which inherently breeds racial polarization. Leaving these necessary updates to the political branches, to Congress, rather than relying on federal courts to continuously engineer racial proportionality through litigation, is the constitutionally sound approach.
The grim irony of that argument is absolutely staggering. Listen to what you are saying. The core justification for sunsetting the Voting Rights Act, the argument Thomas and Kavanaugh are advancing, is the assertion that conditions have improved. They argue that we no longer need these extraordinary federal remedies because systemic racial discrimination in voting is a relic of the past.
The data shows massive improvements in minority voter registration and turnout since 1965.
Yes, because of the Voting Rights Act. And look what happens the exact moment the court relaxes its grip. The absolute moment federal oversight is paused. States like Alabama immediately pass maps that a federal court, after rigorous empirical analysis, finds a mathematically entrenched racial discrimination. We aren't talking about hypothetical backsliding. We saw this exact dynamic play out in 2013 when the court gutted the preclearance formula in Shelby County v. Holder. Chief Justice Roberts said the South had changed. Within hours of that ruling, states across the South passed highly restrictive voting laws that had previously been blocked by the DOJ.
Those laws were passed by democratically elected legislatures implementing voter integrity measures.
They were surgical strikes on minority voting access. And now we are seeing the exact same closed loop with Section 2 and redistricting. The procedural and substantive doctrines are colliding to lock minority voters out of any possible relief.
How is it a closed loop? The courts are still hearing these cases.
Look at the mechanics we've discussed today. On the substantive side, the Kalai standard raises the bar so high that plaintiffs must magically disentangle perfectly correlated racial and partisan data, making it mathematically impossible to prove intent. On the procedural side, the Purcell principle raises the bar so high that even if plaintiffs somehow meet the Kalai standard and win at trial, the Supreme Court steps in and says, sorry, it's an election year, we can't intervene.
The court isn't trying to trap plaintiffs. They're trying to return power to the states.
The practical effect is a trap. The Voting Rights Act is already effectively dead in practice. The Supreme Court doesn't even need to formally strike down Section 2. They don't have to write the controversial opinion declaring it unconstitutional. They have simply engineered a procedural labyrinth where no civil rights plaintiff can ever reach the exit. It is a brilliant, devastating, bureaucratic suffocation of a fundamental democratic right.
That is a powerful indictment, but I must argue it fundamentally mischaracterizes the court's structural role. The Supreme Court is not a super legislature. Its job is not to guarantee substantive policy outcomes, and its job is certainly not to ensure proportional racial representation in Congress. Its sole job is to interpret the Constitution and the statutes as they are written.
But they are rewriting the statutes through procedural mechanisms.
By reining in the expansive, race-conscious interpretations of Section 2 that dominated the late 20th century, the court is forcing the law back into alignment with the Equal Protection Clause. The Constitution demands neutrality. Respecting constitutional limits on race in government decision-making and preventing judicial chaos on the eve of elections through Purcell are paramount for the long-term institutional stability of the republic. The Calais standard and the strict application of Purcell ensure that the rules of the game are set by democratic processes, by the people's elected representatives, not by endless litigation and judicial fiat.
And I maintain that prioritizing these abstract procedural doctrines over the substantive, on-the-ground voting rights of real human beings allows states to actively entrench discrimination. It allows them to defy federal law with impunity so long as they play the calendar right. When the court elevates the so-called status quo of an unconstitutional state law over the actual voting rights of its citizens, it sacrifices justice for the mere illusion of order. The complexity of balancing the Voting Rights Act with the 14th Amendment is profound, I admit that, but erasing majority black districts and validating bad faith legislative maneuvering doesn't resolve that constitutional tension. It simply declares a winner by default.
Both of our perspectives highlight the profound structural complexity of this issue. We can certainly agree that the Supreme Court is fundamentally altering the landscape of American elections. The obscure procedural mechanics we've discussed today, like how the Purcell principle determines the status quo and how the Calais test forces statistical disentanglement, often dictate the substantive reality of our democracy far more than sweeping generalized declarations of rights. It is vital to examine these granular mechanics closely because that is where the law actually lives.
Absolutely. The actual mechanisms of the law are where the true power resides. We highly suggest our listeners delve deeper into the source material. Read the full majority opinions and the dissents in Allen v. Milligan and Louisiana v. Calais. Explore the academic frameworks like Dodsworth's analysis of positive and negative Purcell orders to truly understand how these legal tests operate on the ground at the level of the county clerk and the polling station. Think back to that image we started with, a congressional map actively erased, redrawn, and reinstated right before an election. That is not an abstraction. That is the reality millions of voters are navigating today.
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.